One, one, two, one, two. Testing one.
Hello. Settle down. May we settle down, please? We are about to commence the next session. Settle down, please. Dr. Dunoma Yahaya is coming to take over from me. However, to save time, we will constitute the panelists. The panel, after constituted, we will proceed. However, the next on the item or on the program is showcase. However, the Borno State Chief Judge is having other immediately. Having said this, let me invite the chairman for the next session, Honorable Justice Babagana Karumi, PhD. Honorable Justice Babagana Karumi. Other panelists include Modu Grema, ESQ. We also have Dahiru Abubakar from the Supreme Court. We also have Zakaria Mohammed Umar, ESQ. Zakaria Mohammed Umar. We also have Anjali F. Michelia from the Ministry of Justice. Anjali F. Michelia of Justice. Also to join them is Kashim Abdullahi, is to be the chief intervener. If you like, special intervener. Thank you very much.
Personalities here present. My task here is very simple, and due to time constraint, I will try as much as possible to see that I run this session very quickly. The topic we are about to discuss is very apt and relevant, i.e. that's e-filing and e-affidavit. And I think for those of us that have been here when this program started up to this moment, you must have seen the advantages and disadvantages of the technology, so to say, though the face and inadequacies of some of the facilities we need to harness the. Then we have questions, but I think we'll just give each of the panelists, so to say, 3 minutes to share their thoughts on e-filing and e-affidavit. I think to save time, I think let's not be repetitive. If one of the panelists have talked on an issue, I think it's better to discuss an issue that has not been talked upon. So in order to achieve that, I will start with okay, Mr. Grema will give you 5 minutes, no, 3. And I will be very, very, very conscious in meaning that 3 minutes. So you have 3 minutes to share your thoughts with us, and your time starts now. Thank you.
My Lord ECJ, allow me to stand on the yesterday's highly established protocol. The topic for the discussion is e-filing and e-affidavit prospects and challenges. But however, before dwelling into the topic proper, if we talk of e-filing, e-affidavit, then you have to draft something before you file it. And most especially, I think this will be a benefit for especially the young lawyers to go through an overview of the drafting of affidavit itself before now proceed to discuss the prospects and challenges. As you know, affidavit are crucial, recurrent phenomena in our daily legal practices as lawyers. One must come into contact with an affidavit, whether in or out of courtrooms, whether has a record of court or what has taken place as part of what is going on in the situation. So we use affidavit in various ways as a record, affirmation, or oath to confer solemnity on record of what has or about to take place. So drafting of affidavit is very crucial for us to know it. How can we draft an affidavit? Sorry, this is one of the challenges of technology. So affidavit form a major aspect of documentary evidence. Unfortunately, despite its huge role that affidavit plays in our daily interactions as lawyers, little thought is given to its preparation and rule guiding it uses. The outcome of many cases depend on quality of affidavit filed by the respective counsel in the matter, the extent to which the amendment or the disposition comply with the stipulation of various legislation, particularly the Evidence Act and then the Oath Acts. So there are also legal frameworks that guide the drafting of an affidavit. The law governing affidavit in Nigeria, particularly those required for court processes, is the Evidence Act 2011. The Act set out rules in relation to form filing of an affidavit. So, and also there are functions for the affidavit. What are the functions for the affidavit? Courts have enormous powers and responsibility within our adjudication system. One such responsibility is the court's duty to dispense justice to litigant. In practice, this means that when a litigant or a prospective litigant applies for an order of injunction, or court will need to exert its discretion in reaching a decision. This means the judge will have the power and right to act according to the dictates of his personal judgment and conscience, uninfluenced by the judgment or conscience of others. So, however, such judicial discretion cannot be exercised in vacuum. It must be exercised appropriately, taking into account the claim to justice by both sides and relying only on cogent and convincing facts. It is only upon considering such facts that the court will be said to have judicially and judiciously exercised its discretion. Affidavit evidence is the vehicle through which such cogent and convincing facts are supplied. So the general rules for drafting of the affidavit is governed by Section 107 to 120 of the Evidence Act 2011. That is, every affidavit used in the court shall contain only statement of facts and circumstances to which the witness refers to either of his personal knowledge or information that he gathered from another sources. And there are some preliminaries of which we have discussed, which I intend to skip. Things like every affidavit must be headed in the appropriate course, and there are examples also provided. I will supply the details of the research, the details of the presentation to the MBA for onward transmission to the other members of the MBA, and some other aspects of our discussion. Some other aspect of our discussion is the e-affidavit. You know, like the case management that we have, there is a portal which deals with affidavit.
Mr. Grema, you should already know.
And this portal...
You have spent 5 minutes.
My Lord, just one more.
Thank you, Mr. Grema. A round of applause for Mr. Grema.
Sorry, my Lord, I did not deal with
Thank you,
challenges
Mr.
and
Grema.
prospects.
We'll now call on the next panelist, person of Mr. Dahiru Abakar. I don't know whether he will join us online. Oh, he's here. Okay, thank you. Mr. Dahiru Mohammed, you have the floor. You have 5 minutes, and your time starts now.
Thank you, my lord. Good afternoon, everyone. I think I will just move ahead straight to the topic of the discussions, which is the prospects and challenges of e-filing and e-affidavit. What is affidavit? I don't have to talk about that. Before the e-filing in Borno State, things happens to be physical. And Borno State is the first state that started the e-filing in the entire country. Secondly, Borno State is the first state that Allah tested them with a flood. That if not because of the e-filing, their case files will have been missing by that time. To know that the e-filing is very important and it has come to stay in Borno State, even though there are some prospects and there are some challenges. But always, when a challenge is not being identified, that is when it becomes a challenge. But as soon as it has been identified, it can be resolved by any means. First, the prospect of the e-filing and the e-affidavit is efficiency and speed. Under the efficiency of it and the speed, we have the fast processing. Before now, you have to prepare your documents and find your way to the court. But now, it reduces time spending on manual submissions, physical movement of documents, and also court filings. And the litigants or the counsels can also track their cases at any given time that they so wish to do that. And also the availability of the platform for you to file at any given time, 24/7. Effectiveness. It reduces overhead, saves on printing, postage, courier, and administrative costs. Before now, we know, before you file a case, you have to do all those things. Get the papers ready, print them, and find your way to the court. Then it minimizes physical storage. For the court, normally, the court must have an archives where they will now put all the finished matters and also the process unit where they will put all the ongoing cases. All those ones now, with the advent of the technology, you don't need all those things in place now. With a minimal space where you can have a table and then you have your gadgets, you are good to go. Then accessibility and convenience. You can access all your case files remotely from anywhere you are in the world, not in Nigeria alone. And there's simplified submissions. At any given time, you have a right to submit your documents at the middle of the night, on a flight, at anywhere you can file your cases without any worries. Also, for the counsels, they can ask for representations at any given time. If they so wish, another counsel to represent them at any given time is for them only to move their cases to their chambers and then assign that particular user into that chambers, and he have full access to that particular case folder, and he can go ahead. Then, fourthly, transparency and accountability. Real-time tracking. Parties can track, is it? My lord. Parties can track the status of the solutions and case updates. Then the audit fee. Also, it allows for the audit to find out what happens on the case file, not like the ones that happens on the physical method, because if somebody tampers with any case file, it will be difficult for you to trace it. But with the technology, you can easily trace who did that. Environmental benefits, paperless operations, and then support for digital judicial initiative, facilitate broader goals of digital transformations and modernizations of justice system. For the challenges, we know there must be challenges, more especially the digital divide, access inequality, the rural populate and marginalized group may lack internet access, devices, and digital literacy.
Mr. Dai, your time is off.
Thank you, my lord.
Round of applause to Mr. Dai, please. Straight to the next panelist, the Secretary of Nigerian Bar Association, Maiduguri branch. You have 5 minutes to share your thoughts on this, and your time starts now. Thank you.
Thank you, my lord. Good afternoon, all. Mine is to, first of all, draw to our attention that the e-filing system is not only about filing of cases. It is designed in such a way it can be used for the purposes of court services. By saying court services, I mean apart from what we file onto the platform, we can also access the services from the court, from our courts. For instance, record of proceedings. If we don't know, some of our courts, some of our judges have gone ahead of us in utilizing that service or utilizing the e-filing platform. For instance, if a proceedings took place today, in the afternoon or evening hours, I one of you, I can attest to that immediately after the court proceedings, if you click onto or log into your case file, you can easily access the record of proceedings there and there. I can make mention of courts, like for instance, with all respect to our court 4, so also court 8, manned by Justices Amina and Hafsat. Once a proceedings took place, you can easily access the court proceedings there. All what is left there is to know how, or to pave way on how we can get those record of proceedings certified electronically. That is one. And the e-filing platform also unified, is intended or is designed towards unifying all our courts or judiciaries. For instance, Borno have been migrated there, Bayelsa, and now about Lagos. If at all the states are migrated onto the platform, you can easily file your processes anywhere. But then, if we can file the processes anytime, anywhere, now we have a challenge on that. The challenge here is, for instance, I intend to file court process that has to be accompanied with, for instance, witness statement on oath or an affidavit. That we have constraint to that. If I am to file the process, for instance, in the night or evening hours when the court has closed, for instance, my friend, the commissioner for oath, I may encounter hitches there because there will be no commissioner for oath to frank my affidavit or witness statement on oath. So it is now I think it is high time for us to have electronic means of franking such affidavits or statement on oaths. Thank you.
Thank you, Mr. I think it's kind enough to save us a lot of time. I think next is Mr. Angeli F. Michelia from the Ministry of Justice, Borno State. At least you have 5 minutes to share your thoughts with us. Thank you.
Thank you, Mr. Chairman. All protocols duly observed. Good afternoon, gentlemen. First of all, I would like to say I don't feel comfortable discussing prospects of e-filing in Borno State, something that has been in existence for over 2 years. We should be talking about the accomplishments of e-filing in Borno State. We are all aware that e-filing has been in existence for a while, and we have all benefited from the e-filing system. I will draw the attention of the audience to our case in the Ministry of Justice as a beneficiary of the e-filing system. The e-filing system has actually contributed a lot because we now have round-the-clock filing. I heard my fellow discussants saying you can file it in the plane. Yes, it's true. But while doing that, absolute care must be taken because I'm aware of a friend who filed his charge, but due to lack of diligence, we later realized that his name appeared as the defendant. So that's why you should be very careful with doing such things. It is also very fast. We have noticed that. We've noticed the swiftness in court proceedings. After you must have uploaded your documents, sometimes before you go back to your office, you receive your case number, and then the hearing notice to start processing your summons for the defendant. The e-filing has also helped reduce delays by cutting down the time spent on manual, the time traveling to file your processes. We are all in the picture that our division is active. We have colleagues that travel there on a daily basis to try their cases there. Now, the cost of transportation all has gone because of the e-filing. They do that for the comfort of their offices. In fact, even the environment is happy because it means less emission, it means less paper in the dustbins and all that. So it creates an eco-friendly environment for the state. So these are my little contributions. Thank you very much.
Thank you, Mr. Shevia. I think the panelists are doing justice to the topics because they are very, very mindful of time. The next panelist that will listen to is Mr. Kashmir from the State Judiciary. So you have 5 minutes and we'll be ready to summarize your thoughts. Less than 5 minutes. Thank you.
Because of the time constraint, let me go straight to the topics. On the prospect of e-filing the affidavits, and in bringing out the prospects, I would like to trace the evolution of being a digital judiciary. Firstly, it was during the pandemic, that's 2020, when my Lord in his wisdom deployed the NCMS, which serves as a footrace to all the scalability we are now witnessing. First, the NCMS, then during 2023, the e-filing was unrolled. So I totally agree with F. Michelia when he said we shouldn't be talking about prospects. We should be talking about achievement and more innovations. Because the e-filing now is no longer a technological convenience, but we see it as a tool for enhancing access to justice, judicial efficiency, and institutional transparency. The next scale is the e-affidavit. The e-affidavit that is about to be unrolled very soon. It's intended to achieve end-to-end digital workflow. That's what I have to say.
Thank you very much. I think I have very members of the panel that are very mindful of time. And the next person we'll listen to is the special intervener who I cannot regulate. Okay, so that would be fine. I think I will take as few questions as possible because we are running out of time and today is the closing. So what I will do is I will take 2 questions here, 2 no questions from the center. Fine. Okay, 3. Okay, start with, yes, can we have another mic, please? No protocols, please. Just tell us your name and straight to your questions, your contribution. You have 30 seconds.
Thank you. My name is Muhammad Umar Ali. My question is whether a council being in a matter can complain of being served with the process physically. After hearing, maybe he is a plaintiff in the matter, the defendant was engaged with counsel, and maybe if he can complain, must be served with the statement of defense physically. In a simple note, maybe if my question is not clear, that counsel. Yes.
Can he later complain? That's when he serves electronically.
Maybe if the service of the electrical service is allowed by Allah.
Whether it's allowed.
Yes,
Yes.
ma'am.
Thank you. Yes, Mr. Adam.
Yes, thank you. I am Muhammad Adam from Amana Chambers. I have my first question is there a provision on the e-filing portal for addition of a party in the event of joinder, maybe a claimant or a defendant, for you to go on the portal and add a party where step?
That's when you obtain the leave of the court to... Yes. Yes, my lord. Yes, my lord.
Assuming a case was commenced by originating summons, and subsequently the court ordered pleadings that the case to proceed for the case to proceed by way of writ of summons. Is there provision on the e-filing portal to go and find your writ of summons on the portal? Pleadings. Yes, for pleadings, because the mode of initiating originating process are listed. So if a case has begun by originating summons, can you later, after the court ordered for you to file writ of summons, is there provision on the portal to upload your writ of summons and other pleadings? That's my questions.
Okay, thank you. Yes, from the behind, I'm seeing the hand. Okay, so we're done with this side, right? Okay, from this side, no question. Okay. Maximum, I hope your maxims will be e-maxims. You have 30 seconds. 30 seconds.
Sir, we want to know more about these technical glitches. What these technical glitches, how to avoid it and how to rectify it? Because it starts getting as it is a defense before a court, because there are instances where the judge or the court will get prepared but to listen to emotion. But when the respondent will say, I'm not ready, because my emotion has not dropped. It's with the case management, and the blame will be shifted to the case manager. It's like it's getting defense. So you want serious clarification on this one.
Yes. Thank you. I think it's Yes.
Yes, my name is Peter Bola. My question is in respect to challenge filing, when it has to do with
you said what?
challenges in filing cases under the matrimonial process rule. Okay. There are certain subheadings that are not available within the case filing, especially when you file things in respect to conference and also filing the certificate of compulsory conference. There is no subheading within the case management board to file that. and also when you want to file terms of settlement, and also the terms of settlement that has been reached. I think
No, not TV.
Person from the Supreme Court. Thank you.
Thank you. Mine technically geared towards the managers of the NCMS. I could vividly recall they trained us since 2020, 2021, immediately after the COVID-19 pandemic. I wrote now the question is, in order to satisfy the concerns of Zakaria and all the populace, as well as the legal practitioners in litigation, how do we now bring the NCMS or bring the notaries public? Because it is now there is a digital notarization. If you access
Yes, I think we'll just take few responses from Mr. Kashim, then Mr. Dairu. Okay, Mr. Dairu, you're starting. Okay. So please just be specific to some issues.
Good afternoon once again. I will take from the first questioner. He asked about service. Normally, what happens on the service, there must be a first physical service. When somebody sue, the dependent is not even aware that you have taken him to court. That one, the court must go and serve him. How did you do the service? The NCMS. The e-filing serve both parties at the real time. You can't deny that you are not being served. And the portal also is going to show that you are being served. Then, since that you know you are a counsel to one of the parties.
To what he has said, I think you are predicating your question based on a practice direction that says service on NCMS is enough. So that is without prejudice to personal service.
To add a party. But to my own knowledge, the council has no right to add a party to an existing case without the knowledge of the judge. Judge has granted, then he becomes a party.
No. He has asked whether he can file a writ where there is an order